Arabelle on Instagram, Kenneth Boggs, good morning. Billy, good morning. Mom Triple K Hottie, good morning. Okay, I'm finally live on Facebook and YouTube. Good morning. Good morning, everyone. Hope you guys are having a great day and hope you had a wonderful weekend. Um, I'm on live here today to just talk about immigration and whatever else is going on with immigration and to answer as many questions as I can. Um, if you would like to schedule a consultation, our number here is 407 995 6567. Let me just write that down here before I start. You can start typing your questions and then I will get to them once I put in my number. And then if this is your first time tuning in, welcome. My name is Aisha. Um, I'm an immigration lawyer here in Atlanta, Georgia, but I present clients in all 50 United States. So it doesn't matter where you are. We can assist you with your case, and we handle pretty much everything. 1 second, guys. I'm just trying to make sure I put the right numbers in there. So these are our phone numbers. Let me pin it. Sharika on YouTube. Hey girl, what's up? Thank you so much. Says I love you. You're the best. Thank you. I appreciate it. Someone says, if I apply for a marriage-based green card now, when will I receive my work permit? And are there any chances I'll receive my interview before my permit as per the conditions going nowadays? I can't specifically tell you when you receive your work permit because now it depends on what country you're from. I don't know what country you're from. There's certain countries where work permits are on pause. But that said, if your country is not one of those on pause, the normal timeline for most people to receive their work permit is somewhere between 6 to 11 months. Sometimes some people get it much earlier. Sometimes some people get it. They usually get it within, sometimes they may get their interview earlier because interviews are also 6 to 13 months. And so what that means is sometimes you might actually get your interview before your work permit, or sometimes we've had where someone doesn't have their work permit, they go to the interview and before by the next day they issue them their work permit. And so before they even issue like a decision on their case. So it's anything would tell you basically is just a variable, we can't really predict, but that's just a timeline. All right. Someone's asking, are visas still on pause? So I'm assuming by you asking visas, you're referring to cases outside of the United States, the 75 countries that have the pause. If that's your question, the answer is yes, they are still on pause. If you are part of the 75 countries outside that are trying to apply from outside the United States into the US. As far as the pause here in the US, they haven't outrightly said they've lifted the ban. The only thing that we noticed last week was that a lot of cases from those countries where they have these are going to be the 39 countries with the adjudicative hold here in the US. A lot of those countries where we had those interviews that were canceled because of the pause, we have them that we see that they're rescheduling those. So time will tell. We just started April, so let's see what happens. I think I posted an update on that, and then basically now going through them each all by individual cases. If they pass Operation Paris, I think it's what it's called, like it's their review process or whatever it is that they're doing. So as I find out more, I will always update you guys and give you guys the most current update. Okay, so let's see what else. Other questions I have here. Okay, the person that asked a question about if you apply for a marriage-based green card, when will they receive their work permit? It could be anywhere from 6 to 11 months. You can fall anywhere in that window sometimes. And your other question is it possible that you have an interview before your work permit? It is possible. So meaning it could be before or after it. Everyone's case is different. Do you have jurisdiction in Massachusetts? I want to apply for a T visa with your office. Would I need written or video of people who witness? So immigration is federal law, which means that every licensed attorney can represent any client in any state in the United States for immigration because it's federal law. There are certain types of law that are state law. In those cases, we can represent you. So for instance, if you have a business dispute with a business partner, I would only be able to represent you in say Georgia, New York, or Florida, where I have my legal license, my law license. But in other states, you need someone that's licensed in that state to be able to represent you. So yeah. Someone says, can people with pending I-751s travel? If you have a pending I-751 and you have, your green card extension, meaning the 48-month extension they gave you has not expired, you don't have any criminal records, you are currently in the correct application. What I mean by correct application is, let's say if you filed a joint filing, you're still in a joint marriage and everything is wonderful, because you don't want to be divorced and filing for a joint filing, and you haven't amended your case and you travel. And then when you come back and they see that and they bring into secondary, they will still let you back in the country, but you'll go through a grueling secondary inspection. So if you have any criminal records, especially in more recent times, definitely do not travel. But otherwise, it's most people are usually able to travel. Whenever you guys ask me these questions about travel, it's very hard for me or any other attorney to answer the question, because the answer is unfortunately not generic. It's not a one size fit all. Travel is such a nuanced thing that I need to know your own case personally, your own immigration history personally, to be able to tell you whether or not you can travel. I can have two of my clients send an email saying that they want to travel. They both have I-751s pending, and we might have even filed on the same day. And my answer to both of them will be different based on my assessment of their case and what their cases are. Well, does this person have a criminal record? Have we got a request for evidence for this person, though we've submitted an NOID? Have they gone to an interview? Are we in a waiting stage? So there's just so many variables. So, I know you guys come in here and you ask these questions, just thinking it's a one size fit all. And that's why, when they say schedule consultations for your own specific case, that's the reason why, because every case is different. And so I need to really understand your own immigration history to say, you, John, obviously there are always the risk advisories, but I think you should be relatively safe. And then for me to say to Jane, hell no, you should not be traveling right now. So it's very, very varied, depending on each person. I had all my biometrics for VAWA done 2 weeks ago. What's the likely timeline for EAD and travel permit? Just talked about that earlier, 6 to 11 months on average, unless you're from one of the 39 countries. If you're one of the 39 countries, that's really delayed. I can't really give you a predictable timeline until I see movement. Until then, I can't really say. At minimum, whatever timeline we give, you want to put an additional 3 to 5 months there, until we find out something more quantitative to explain. My priority date is currently on now. And would you advise me to go for my interview for my family-based visa once the interview date is set because of the visa ban in Nigeria? Well, you have no choice but to go for your interview. If you don't go for your interview, you'll be denied. Yes, if you go for your interview, they will most likely not approve it, but they could put you in administrative hold or based on the ban, or basically tell you they can't approve you based on the ban. And then, once the ban is lifted, you can then kind of use your I-130 approval to basically, make that outreach, saying the ban has been lifted, since that's the basis in which they denied you, because your I-130 will not expire, as long as you keep, touching that application at least once a year. So, and the earliest for any ban outside the country that we're really going to know anything about is June, because, as according to them, 180 days, which is 6 months, is when they will review any of those bands outside to reassess whether they've now finally met all the document requirements to take those cases. And that's part of also the pause here. One of the things they're doing is creating, based on each country and the 39 country, recreating how to identify documents. If you guys look on U.S. Department of State, which is like travel.gov, there's something called the reciprocity table. And this table basically has each country, basically, that U.S. grants visas to. And then on there, it has specific requirements for specific countries, what they would consider, i.e., as a valid marriage, a valid divorce, a valid birth certificate, and things like that. So, obviously, it seems that with certain, they're going to be doing some amendment or saying, where if they agreed and said, okay, this will be considered valid, now they're no longer considering this thing valid and they're wanting more. So that's something definitely to be checking every time you want to apply to determine what is valid. For instance, right now, when you look at the reciprocity table for a country like Nigeria, who's on the 39 country pause list, when you have a customary marriage, USCIS considers that as a valid marriage. But something they consider as a valid marriage, but something interesting or new that they added, which I didn't see last year, so this year, was that you can get like a customary court from the magistrate court. I got to go back on the reciprocity table now and check it to get documentation. They do write the language there that ordinarily a lot of people don't have documentation because that's not the standard in those countries. But what it seems that they're trying to do is that they're trying to, even though that's not the standard in that country, they're trying to get a paper trail as to how they can identify that, because then what may stop someone from stating that, this was a marriage, whereas it wasn't, or whatever it is, or whatever secondary evidence. So I suspect that's what they're doing. But guys, again, when anything for the pause change or anything for the ban change, I will be the first to tell you guys. You won't need to be asking me every single day. I will let you know. Okay. For someone that has a valid green card and gets denied for a marriage case, can he get his green card revoked? I'm sorry, I don't understand what your question is. So you have a valid green card. If you have a valid green card, then why do you have a marriage case? I don't understand the question. Meaning, are you like petitioning for someone for marriage? Is that what you're doing? I'm not sure I understand the question. Someone's asking, can you take a case I already have going? The answer is going to depend what stage the case is and what exactly we're taking over. We don't just take over cases to take over cases. Well, one, you have to have a viable case, because a lot of people go and submit cases that don't actually exist or they're not eligible for. So that's the first thing that we'll be looking at when we assess your case. We'll be looking at what stage your case is. Sometimes there's nothing to take over, meaning your case is processing normally. So we'll say, okay, you know what, we can take note of this, so that once you receive an update and there's work for us to do, then we can do it, because we don't want to hold on to your money if there's nothing for us to do in your case, if your case is processing or progressing in the way it's meant to go. So the answer to that is really going to depend on assessing your case. One of the things that we personally like to do is get a FOIA, which is a FOIA is just FOIA, which means Freedom of Information Act, which basically allows us to get your entire alien file, which is your entire immigration history and documents directly from USCIS. When you can, it's always best to, sorry guys, I'm about to sneeze. It's trying to come out, but it's not coming out. So that's why I'm just doing this on my notes. But anyway, when you, we prefer for you to have, like, if you submit a case pro se means that you submit a case by yourself. If you submit a case by yourself, it is very, 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 very important that you scan and keep every single thing that you submitted. Because what happens now, or what is happening right now, is that with the FOIAs, The FOIAs are redacting so much. I've never had to appeal FOIAs the way that we're appealing FOIAs right now, where they're claiming this rule or that rule of privacy or protection, that when we get this FOIAs is redacted. Redacted means that they've blurred out the entire page, so it's blank. They literally send you a blank page that's redacted. So many things you cannot decipher based on that. So it is very helpful when you file your case, especially if you're doing it by yourself and you then want to pass it on to an attorney, that you have a full record of what you submitted, down to the tracking number. You should never, ever be mailing something to USCIS that you cannot track, meaning there should always be a tracking number. Do not cheap out and go to the post office and just mail it and not get a tracking number, right? That you can pay like an additional $5 for. Get a tracking number. And understand this. USPS, which is the United Postal Service, after 4 months, it will scrub your information off of the internet. You will not be able to track that case again. So if you mail something, especially when you do it yourself, you must always go and check that tracking the week, 2 weeks after you mail it. Basically, you want to track it until it's delivered. And when it's delivered, you want to screenshot it and save it. Because 4 months later, when you're trying to figure out, well, I haven't gotten a receipt. Did my file get into USCIS? Did blah, blah, blah get in there? You want to be able to show that you have evidence that it was delivered to USCIS. If you're working with an attorney, hopefully your attorney tracks your stuff and has a copy of your stuff. If we're taking over your case, we can go to the attorneys directly to try to see if we can get the file, because at least it won't be redacted. But otherwise, if we can't get it from you or from the attorney, we have to do a FOIA. But understanding that FOIA has its limitations right now because of the amount of stuff they redacted. In the past, like if you had a marriage case, there are many more things I could see like a Stokes interview, like answers from both spouses, like in a Stokes interview. Stokes interview is like when they separate the two clients. But now, like, they just blur out everything from the I-130 because technically it's not your application. That's your spouse's application. So they're not willing to give us that. So that's why it's good to document everything. I have two cases. I have a marriage case and a VAWA case. The VAWA has been approved, green card has been issued, but received a letter that the marriage case has been denied. What do I do? So, well, obviously, they can't approve you for two cases. If you're married, what is the basis of the denial? If your VAWA case was already approved with the green card, then usually your denial letter should state that you've already received the benefits through another means. That's what your denial letter should say. So confirm that that's what your denial letter says, because they can't approve you for two green cards. You can only have one green card. It's not like a work permit where you can get two work permits from two different cases pending, but you can't in a green card situation. Ramot Sway is asking, what is the rate of denial after you receive a prima facie? Just asking generally from your experience. If you have a prima facie, I know you can still get denied. Trying to understand what the general rate of denial is. I fully understand that all cases are based on individual facts. I don't know. I can't tell you, unfortunately. I don't know. You know, a prima facie doesn't mean that you get your case approved, but I don't have any statistics to give you. So I wouldn't worry myself or yourself about that. Instead, focus on making sure that your own application is strong enough. A prima facie just means that you've met the preliminary requirements, meaning if they're going through the basics in the filing room, okay, these are the elements, okay, there's a marriage certificate here, there's a divorce certificate here, there's a proof of, some cohabitation documents or evidence they've sent here, there's, proof of good moral character, or this person came into America in 2025 and we only have FBI clearance. That's not enough. We know we need to go 3 years back. We're going to send an RFE before we issue a prima facie for more proof of good moral character. I'm just using that as an example. So basically, they're not reviewing your case. It's just for the bare basics. First of all, that you meet the bare basics in your element. So whatever the statistics are of anyone filing for a VAWA case, who are the people approved and unapproved, the statistics are the same. So I can't tell you what your statistic is for you personally. I don't know your case. I don't know what you filed, or anybody else's statistic. You just talk about, I can only speak about, my firm, and our own statistics. For us, we're not trying to get you a prima facie determination letter. We're trying to get you an approval, because we know that a prima facie determination letter means absolutely nothing, other than, for a lot of, for some states, it allows you to work. Let me correct myself. It's not that it means absolutely nothing, but in terms of, it means nothing to your ultimate approval, meaning you can have a prima facie that allows you to get financial aid, that in certain states allows you to get public assistance, in certain states allows you to get a driver's license, which are all benefits, but it does not guarantee an approval, or doesn't. So I can't really give you any kind of statistic to it, unfortunately. If my case was updated March 19th and I'm from one of the post country, what does it mean? I don't know, because I don't know what your case is and what they updated it, unfortunately. Sorry. Favor, the best immigration lawyer. I thank God for blessing me to come across your path. That changed my life. Oh, thank you so much, Favor. Okay, let's see what else we got here. Child Cancer says, I love your hair and makeup, so natural. Thank you so much. Can an overstay travel and advance parole with a pending VAWA? Again, it's the same thing I explained earlier. I need to know your own personal immigration history to be able to tell you whether or not you're eligible to travel. There's certain things that we consider when we say travel or don't travel. One thing I'll tell you guys, we had this happen recently where a client's case was going normally. They had traveled several times back and forth internationally. And for whatever reason, when they went with their valid advance parole to USCIS, to the airport, they were asking questions about their immigration case or their advance parole, and the person started running, and the person ended up getting detained. There is no reason to run from a law enforcement officer, because if you were not going to get detained and just all they were doing was placing you in secondary inspection to ask you more questions, you running is an indication, or you make them, first of all, you're violating a law by running from a law enforcement officer who has stopped you to ask your question, and you have basically created a reasonable belief that you're doing something wrong. If you have valid documents, you should stand in your valid documents and make sure that you can prove that you have this advance parole that allows you to travel, you have a pending case. That's literally what it's there for, because if they were not planning to allow people come back in, there's no point of them approving advance parole. So that's one thing you guys need to know. And a lot of times, if something like that happens and then they bring you in and then they detain you and put their arriving alien on your document, you're not eligible for bond. So you go from having a really lovely case to now you're in detention and you can't even get out of detention other than through habeas. And then with habeas, you're making the argument that this person is not a flight risk. But the first thing you did was you ran. That's literally what flight risk means. And again, this was a circumstance where we were notified. It is so important that if you have a lawyer, that before you travel, you must always check with your lawyer. You must always check with your lawyer that, is it okay for me to travel? And don't take it personal if they tell you no, because we're telling you no because we want to protect your interests. We don't derive joy from stopping people from traveling or living their best lives. Okay. I can't answer any more questions. I gotta go. But if you would like to schedule a consultation, my number is right here. You know, it's in my profile in all my accounts: Instagram, Facebook, YouTube, TikTok, whatever. It's 407-995 or 407-995-6567 or 678-325-1037. You can also WhatsApp us on 404-333-8751. Schedule a consultation. A lot of you guys ask questions that somehow you want me to answer, but I can't really give you an accurate answer because I don't know your immigration history. So schedule a consult. We'll talk about your immigration history and what you are eligible for or not eligible for. All right, guys. I hope you guys have a good day. And I will be on live tomorrow at 10 a.m. Eastern Standard Time, so you can tune in if I didn't answer your generic question. All right, guys. Bye.